South Carolinians would no longer be forced to fund radical activist organizations like Planned Parenthood.
States are free to block the abortion industry from Medicaid funding after a major Supreme Court decision. The case, Medina v. Planned Parenthood South Atlantic, centered around a patient's ability to sue to choose their doctors. The decision could have nationwide implications by allowing states to redirect taxpayer dollars away from abortion facilities like Planned Parenthood. Let's break this down. In 2018, South Carolina Governor Henry McMaster's executive order blocked clinics that provided abortions from receiving Medicaid reimbursements. While federal funding is generally blocked from going towards abortions, McMaster argued that abortion clinics could use the money for other purposes. A patient alongside Planned Parenthood sued, saying that the order violated a provision in the Medicaid Act which allows any patient eligible for Medicaid to seek health care from any qualified provider.
Well, it's up to the states to determine who is a qualified provider under Medicaid and who's eligible to receive reimbursement based on being a qualified provider.
The Supreme Court has ruled 6-3 that Medicaid beneficiaries do not have the right to sue to enforce the Any Qualified Provider measure of the program. South Carolina Governor Henry McMaster released a statement saying that the legality of my executive order prohibiting taxpayer dollars from being used to fund abortion providers like Planned Parenthood has been affirmed by the highest court in the land. John Bursch, Senior Counsel and Vice President of Appellate Advocacy with the Alliance Defending Freedom, the firm that defended the state of South Carolina, joins us now to talk about this big win for life. John, the case centered on a beneficiary's right to sue. The justices found that while Medicaid law allows people to choose their own provider, that does not make it a right enforceable in court. The opinion written by Justice Neil Gorsuch said that to prove that a statute secures an enforceable right, a plaintiff must show that the law in question clearly and unambiguously uses rights-creating language. He determined that the provision in the Medicaid Act does not have that language. Can you elaborate on this?
Yeah, this is one of those cases where if you're not a lawyer, it may be hard to understand what the significance is. But what happened here is that South Carolina and more than a dozen other states about a decade ago all tried to defund Planned Parenthood as part of their state Medicaid program for a variety of reasons. And what the Planned Parenthood response was to recruit beneficiaries, women who had attended a Planned Parenthood for whatever reason or wanted to, who had Medicaid, and then brought federal lawsuits in federal court and demanded that they be reinstated. And there were sympathetic federal district court judges who were only too happy to put Planned Parenthood back on the payroll, and the majority of the Court of Appeals did the same. But the U.S. Supreme Court confirmed this week that they do not have the right to do that, and so that gives states the flexibility to be able to defund Planned Parenthood. And we know how important that is because between 2018 and 2023, Planned Parenthood nationally, including all of its affiliates, received more than $3.2 billion in public funding. So if the states can stop paying Planned Parenthood through Medicaid, and then the federal government will stop paying Planned Parenthood if the legislative bill goes through on the budget, we're going to be able to close many of the Planned Parenthood clinics simply because they'll run out of money.
Do you think that there will be a push in Congress now to make language more specific when it comes to Medicaid coverage and rights? If so, how does that impact Planned Parenthood?
I don't think that there's going to be an amendment to this particular statute because polls show that the majority of Americans do not support taxpayer dollars going to Planned Parenthood. The U.S. Supreme Court was exactly right to say that there was no clear rights-creating language in the statute, and so that beneficiaries did not have the right to sue. If a provider like Planned Parenthood wants to challenge a disqualification, they can do that through a state administrative appeal and then an appeal to the state courts. In South Carolina's case, Planned Parenthood blew the deadline, according to South Carolina, and so they may not have an opportunity to appeal even through that state system. But that's on them. That's not on the statute. That's not on Congress. People need to understand that when Planned Parenthood signed its contract to be a Medicaid provider in South Carolina, it agreed that its exclusive remedy was that state administrative appeal. And yet it just broke that promise and went straight to federal court so that it could try to get damages and attorney fee shifting against the state of South Carolina.
Are there other states with laws similar to those in South Carolina, and do you see them following suit?
There are many states that have already tried to disqualify disqualify Planned Parenthood and have been unable to do so because of these federal court injunctions. And I'm confident that many of them will go back and ask those injunctions to be lifted. There are innumerable reasons why states have defunded Planned Parenthood. In the case of South Carolina, they didn't want any public dollars going to an organization that provides abortion. In other states, they're concerned that Planned Parenthood is not only the largest abortion provider in the United States, but the second largest provider of dangerous experimental drugs for children who have gender dysphoria, like puberty blockers and cross-sex hormones. Others are concerned about the deplorable conditions and the lack of health care that's being provided at Planned Parenthoods. And still others are concerned because of the controversy several years ago when it was revealed that Planned Parenthood was apparently selling and transferring fetal body parts and tissue. So you put all that together, there are many states that will want to do this. And now that the Supreme Court has cleared the path for that, I'm confident that many of them will.
And John, what does the ruling tell us about the direction the Supreme Court is heading when it comes to challenges like these, particularly those tied to state decisions on Medicaid funding?
Well, I think the court, as it has done over its history, is very deferential to states when it comes to funding decisions like this. As the court explains in its decision, a spending clause program like this is one where the federal government isn't enacting positive law, but instead is holding out money and saying, we want the states to administer this. And in a contract situation like that, you need to be crystal clear before you impose on states an obligation to defend lawsuits in federal court with attorney fee shifting if someone's unhappy about a disqualification. There have been more than 9,000 providers who have been disqualified all across the country. And if the Supreme Court had gone the other way, or if Congress had written a different statute, then every single one of those disqualified providers would be filing a federal lawsuit. But what that does is it takes time from the state attorney general's office, and even more importantly, it shifts money to attorney's fees and damages instead of to Medicaid beneficiaries, which is where Congress wanted the money to go. So I think this is part of a trend that we'll see continue of being deferential to states.
Well, John, thank you so much for coming on and explaining this so clearly to us.
My pleasure. God bless.
God bless.